Brian, you may begin.
Thank you, sir. Good morning, good afternoon, and good evening. On behalf of the U.S. Commercial Service, in coordination with the District Export Centers or Councils for New Jersey, San Diego, and Connecticut, we welcome all of you to the third webinar of a 10-part export compliance series during Export Week 2023. Today's webinar is titled An Overview of the Office of Foreign Asset Controls and Sanctions. My name is Brian Beams. I am your host for today's session. The producer of the series is Tony Sargis. Before we get going, a couple housekeeping notes. Everyone is currently on listen-only mode. This session will be recorded. If you object, please disconnect at this time. Participants can write in a question into the Q&A feature at any time during this presentation. Next week, we will send out the entire week's recordings, resource materials to all the registrants. An email will go out then at the end of, or I should say the beginning of June, for all recordings and resource materials of the 10-part series. Lastly, the views and opinions expressed in this presentation may not reflect the official policy or position of the U.S. government. I'd like to introduce Alfredo Fernandez, partner with Shipman and Goodwin LLP. Alfredo, over to you, sir.
Good afternoon, everybody from Hartford, Connecticut, where my colleague John Rutherford and I sit most days. I'm the chair of our international trade practice at the firm and also chair of the firm's manufacturing team. John's on our international trade team, assisting me and others on various international trade matters, including, very relevantly for today's topic, economic sanctions. So today we're going to go over, the basics of economic sanctions, and this is an introductory course by design, so we won't necessarily get into the nitty-gritty details of any one particular sanctions program, but we'll overview what sanctions are and the U.S. agency that primarily administers the sanctions, called OFAC. So we'll begin with a quote that tells a story. Sanctions are the new FCPA, and the FCPA, for the uninitiated, is the Foreign Corrupt Practices Act. This sentence, or potentially slightly revised, from about a year ago, was from the Deputy Attorney General Lisa Monaco to a speech to the regulated community. And if you remember where the world was about this time a year ago, this was several weeks after the Russia-Ukraine conflict had escalated significantly. Lots of sanctions had been imposed. The world economy was kind of adjusting to the world post-major sanctions. And then this was an official from the Department of Justice telling the regulated community sanctions are a really big priority for us. And her reference to the FCPA here is significant because for years, that was a big ticket, high profile, major enforcement priority for the Department of Justice and other U.S. government agencies that ended up with some eyebrow-raising penalty numbers, major settlements, major enforcement work and resources towards the FCPA. The fact that she's saying sanctions are taking over that as a high priority, high focus area for regulatory enforcement is a major wake-up call to the community that these sanctions are important for U.S. businesses primarily, but also non-U.S. businesses that get caught in there as well, to be in compliance and be able to operate their businesses within the boundaries and parameters that the sanctions lay out for us. So I'm going to hand it over to my colleague John, who's going to give a little bit of the 101 of sanctions in general and the Office of Foreign Asset Controls as the agency most relevant here.
So starting our dive into the Office of Foreign Assets Control, or otherwise known as OFAC, they serve as the regulatory authority responsible for economic and trade sanctions designed to further U.S. foreign policy. OFAC will follow this directive by implementing prohibitions against specifically designated entities. These may take the form of individuals, businesses, vessels, and foreign financial institutions. Sanctions targets may include foreign countries and regimes like the government of North Korea, individual persons such as arms dealers or drug traffickers, and in general, any other threat to the foreign interest of the United States. Um, OFAC's mission is comprehensive, and it can involve multiple actions, including the identification of foreign adversaries, the development of sanctions programs, assisting U.S. persons with avoiding sanctions, as well as penalizing them when they run afoul of run afoul of sanctions laws. We can move on to the next one. Okay. While OFAC's economic sanctions programs have the effect of curtailing business with foreign targets, the regulations themselves are set against U.S. persons and entities. Those will include U.S. citizens, persons residing within the U.S. or the United States, um, any entities operating within the boundaries of U.S. territory, entities incorporated in the United States, as well as their foreign branches, of those entities. The main consideration that we want you to have when you think of OFAC jurisdiction is the concept of a U.S. nexus. Um, the U.S. nexus would pretty much entail any connection to the United States that would involve that would bring OFAC involvement. Examples of these will include U.S. persons, products of the United States, or any transaction that takes place or involves a U.S. territory.
Yeah.
Alfredo, do you have anything you want to add?
Sure. That's a good point. That U.S. nexus point is very important, and sometimes it can stray in either direction. As we noted here on the bullet that says sometimes in brackets, a lot of times a foreign subsidiary of a U.S. company is not necessarily trapped by the same restrictions that a U.S. parent is. That's not the case for every sanctions program. Countries like Iran and Cuba will attach to foreign subsidiaries, but many others will not allow it as long as there's no other prohibited action like the involvement of a U.S. person or activity on U.S. soil. Just the very corporate relationship between a U.S. parent and a foreign subsidiary is essentially determined to be not a U.S. nexus in some cases, but other types of U.S. and foreign country or forced jurisdiction business connections would be a U.S. nexus. So it is a little bit slippery there. And with our last bullet here too, I'll add, John, secondary sanctions are a bit of a unique beast where what you've talked about on the top 75% of this slide are referred to as primary sanctions with the U.S. nexus. Secondary sanctions expand that scope pretty aggressively, and OFAC basically says we are going to regulate something without a U.S. nexus in a way to put the world on notice that if you play in this space that we've designated as a focus area, you run the risk of becoming sanctioned yourself. So say, for example, if they designate the Russian petroleum sector as a focus area subject to secondary sanctions, this is just hypothetically, the world is put on notice that OFAC is looking at that, and that non-U.S. persons that may not otherwise be subject to OFAC's jurisdiction, if they're a major player, may find themselves being added to a list such as the SDN list that we'll get into in a few slides as well. So they're used sparingly, but they are important tools that do come up and broaden the net, so to speak, for OFAC's jurisdiction. We'll move you up here one slide, John.
Thank you. So all sanctions generally will prohibit transactions with those sanctioned entities. U.S. sanctions can take the form of statutes, regulations, executive orders, and interpretive guidance. Sanctions issued by OFAC will take one of three forms: either comprehensive sanctions, selective sanctions, or list-based sanctions. A comprehensive sanction prohibits all trade with a specific country or region, absent any form of exemption. All interactions and activities are prohibited, including exporting and importing of product, as well as financial transaction or services of any kind. Pretty much what you want to know with comprehensive sanctions or embargoes are that all dealings are prohibited absent any further exemption. Selective sanctions prohibit all interactions with specific sectors of a region or country's economy. Examples include the energy sector of Venezuela, where in 2019, OFAC designated the state-controlled oil and energy company PDVSA as a blocked entity. So while U.S. persons can still legally transact with other Venezuelan actors, an extensive portion of that country's energy sector will be completely off limits to U.S. actors. Looking at list-based sanctions, those are used to precisely target persons or entities who pose a threat to U.S. national security concerns. OFAC will, implement these by placing a particular target on the specially designated nationals and blocked persons list, the SDN list. The U.S. has a preference for using these more targeted sanctions over the more comprehensive sanctions sometimes, as those will penalize a specific bad actor without heavy collateral to the associated nation or region.
Oh, let me add some input here, John, as well. OFAC recognizes what's called they call it somewhat informally the 50% rule, but that's what the professionals in this space and an OFAC refer to it as, which states that in OFAC's mind, any entity that's owned 50% or more by any SDN, whether individually or in aggregate, is also considered an SDN, even if that entity, that owned entity, doesn't show up explicitly on a list. So say, Joe Smith is on the SDN list and he owns 51% of company X. Company X might not show up on a list even if you look for it, but that does not mean that company X is not an SDN. And usually it's not that cut and dried with easy numbers, but that is a relevant regulatory issue to keep in mind when figuring out who's a prohibited party and not. And now, while we're focused on OFAC today, and some of the other sessions may have addressed some other lists, such as the Bureau of Industry and Security's entity list, and Department of State keeps their own list, and there's a number of other lists that have different functions managed by different agencies, but altogether, are a collective whole of lists that should be kept in mind when dealing with international parties. And there's also, without getting falling too far off our topic today, there's foreign countries, some of our partners, UK, the EU, etc., maintain their own sanctions lists that aren't necessarily directly relevant for U.S. companies looking to undertake international trade, but they are helpful to consult sometimes just to get a feel for the risk factor of a particular party if they show up on an EU list, even though they're not sanctioned by the U.S. That's a little bit of a data point to consider when you're evaluating your overall risk.
So digging into the SDN list a bit more, any entities placed on the SDN list will have their assets within U.S. jurisdiction completely frozen. Any U.S. entity that would come in contact with those assets, such as, let's say, the case of a bank receiving a wire transfer from a blocked entity, you are required by law to hold and report those assets to OFAC. And then just, I know Alfredo spoke on it the last slide, but keep cognizant of the 50% rule. Any company that's owned 50% or more in the aggregate by an entity, by a blocked entity, will be blocked itself. And you just want to keep note of this. This may not always show up on your basic or your entry level due diligence searches. So when you are engaging in transactions, be aware of the familial relations of your specific entities that you're engaging in to best protect yourself from liability. And then this, So notwithstanding the broad prohibitions imposed by sanctions, there are still channels to conduct business with sanctioned parties or entities if approved by OFAC and, if necessary, any other agencies, such as BIS, the Bureau of Industry and Security. Um, a license from OFAC in particular will either take the form of a general or a specific license. A general license will constitute a blanket authorization for specific transactions set forth in an authorizing regulation promulgated by OFAC and are self-selecting and self-executing. So if you have conducted your due diligence and you believe you fall within the guidelines of the authorizing regulation, then there is no further reason to engage with OFAC and you can carry on with the transaction. These transactions will usually have a wind down period for which that they can actually be utilized, but those are often subject to frequent extensions. So just keep cognizant of the end dates, and you should be in good shape. So absent the existence of one of these general licenses, one may also apply for a specific license, which authorizes an applicant to transact with specific parties that are listed in the application to OFAC. Such a license will be issued on a case-by-case basis and be dependent on the particular facts at hand. In drafting a successful specific license, an applicant should seek to demonstrate to OFAC that the activity that they want to engage in does not run afoul of the prohibitions that have been set in place. OFAC will, looking at the statement of license policy, OFAC will sometimes publish documentation that establishes a favorable licensing regime for those seeking approval for a specific license. So for example, in 2022, OFAC released a statement of license policy instructing entities on how to obtain a specific license to offer Iranian people opportunities for internet online security and social media options in the face of the comprehensive embargo. So stay on the lookout for those. They can help you when you are applying for any specific transactions. Alfredo, anything else we should add?
Great.
No? Okay.
So we'll take a little time here to discuss some of the hot sanctions programs. And, as I mentioned before, this is a high level overview of sanctions and OFAC, broadly. We'll dive a little bit, but not too deep into any particular program. But if there are some specific questions, I do see one about Venezuela in the Q&A, and we'll get to that in a little bit. Feel free to put a question in the Q&A or reach out to us offline if it's a longer fact pattern on any particular sanctions program or facts. Some of the hottest ones, no surprise, I'll group Russia, Belarus, and the Ukraine as one set that are geographically related. Belarus, a strong ally of Russia, and right there geographically near the Ukraine conflict. Very hot, a lot of activity in the last 15 months, and a lot of global attention on what's going on there. Parts of the Ukraine, as many of us know, are essentially under Russian occupation. Crimea has been in that kind of state since almost going on 10 years, believe it or not. And then more recently, the LPR and DPR, which are, some people call them separatist regions, but they are specifically tagged as comprehensively sanctioned, as if they were their own little country. Anything going into those areas would be treated the same as Iran, from an absolute no exports, no dealings, etc. Russia and Belarus are not technically fully embargoed, but they are very, very steeply restricted by the current sanctions. So really only certain EAR 99 goods, for those who attended the BIS intro, that EAR 99 term hopefully means something for you, but not even every EAR 99 item can go to Russia. So that is how locked down it is without actually being a fully comprehensive sanctioned program or embargo. Iran is always very geopolitically relevant for the United States, so that one is in perennially hot status. North Korea, I almost consider taking off the list in preparation for this presentation, but just the other day there was a $500 million enforcement penalty regarding the North Korea sanctions. So on the hot list it stays. Clearly still an important focus area for OFAC. Venezuela, given the political turmoil at the top of the government there, has been hot for several years. And when we get to the question a little bit later on at the end of the presentation, we'll delineate a little bit about what's clear in Venezuela. Venezuela is still generally open for business, except for, as John mentioned, some of the targeted entities and their related sector. And then skipping ahead a little bit to our last two here. In recent years, we've seen more enforcement relating to cybercrime or cyber terrorist cells getting sanctioned and getting added to the list, and some sanctions enforcement related to that. And then even more recently, cryptocurrency as a new financial dynamic that needs to be addressed across all types of legal and regulatory sectors. But we've seen a lot of cryptocurrency exchanges being dinged some pretty large numbers for not really knowing who their customers were and allowing financial transactions with some prohibited parties without sufficient know your customer type diligence. Now, one of the takeaways here is that those hot sanctions programs are not the end all story. There's a lot out there. OFAC manages a bunch. There's no pop quiz on this slide, but we did want to pull in the list. I counted 38 or something the other day. This is right from OFAC's website as to specific OFAC programs that exist. As noted, some of them are all the way corner to corner comprehensive, and others are very narrow. For example, there's a diamond trade set of sanctions that really only affects a pretty narrow number of people there. So it can range in terms of impact to U.S. companies. As I mentioned a minute ago here as well, OFAC enforcement has been hot. Lisa Monaco's statement that sanctions are the new FCPA has proven to be pretty true. Just this year, in the 4 months and change that have existed, in 2023, already $550 million in settlement. And I mentioned that North Korea one was a huge chunk of that. But nevertheless, even without that one, it's still, a crazy number for this early in the year, about a third of the way through the year. So getting this wrong from a compliance standpoint can be very expensive, very problematic. And we'll get into a little bit of what could go wrong, not as a scare tactic, but just as a full disclosure as to what's at stake here with sanctions. That a lot of companies starting their international exporting journey just don't have the background and training on, and hence the emphasis for compliance with a compliance program that we'll also reach a little bit later on in our presentation. So we have some dollar signs here on the screen. Note they are adjusted annually for inflation. So if you attend one of these things next year, don't expect these numbers to have gone down. They will go up with inflation every year by law. And these are on a per violation basis as the maximum penalty. So, maybe one can be dealt with, but the issue that we see most commonly is that some of these violations just occur as a series of events whether it's unknown or known, the same types of things just keep happening, or one transaction can actually amount to 3 or 4 different violations just within OFAC. And these numbers, these max penalty numbers grow, snowball into the multi-million-dollar potential. And they often get negotiated down, and you can shrink that number. But obviously, the bigger max penalty you start with, the bigger your negotiated penalty will be. So, we wanted to make that clear that those numbers can add up and are significant. In addition to the dollar signs, for criminal cases, jail time is realistic, right? We have seen some imprisonment type issues for those actors, and a company can't go to jail, but individuals can. And this is really reserved for individuals that knowingly and willfully break the law or circumvent the law and really just go rogue. This is Nobody's going to jail if you accidentally make a paperwork mistake or you didn't necessarily, follow up on question 38B of a questionnaire, and it was just a mistake. This is, the criminal level is intense for a reason, and it is reserved for those purposefully acting wrongly. In addition to what we have on the slide here, two other considerations for the downside of an OFAC enforcement issue is the PR that goes along with it. That could hurt the brand. It could increase due diligence on your company, whether it's just the day-to-day operations of your business, or if you're in an M&A type of environment, maybe looking to get acquired, that might be a red flag that a potential acquirer is looking at. And it may also affect some of your other licenses, and we'll get to that in a second as well. So in terms of what OFAC would be looking at in an enforcement scenario, and I'm going to trust nobody on this call is going to find themselves in an enforcement scenario, because you're going to take our recommendations that will be coming up soon. They're going to be looking at your conduct, willful or reckless, or was it just an accident, maybe a lack of training, maybe a lack of resources, lack of support, some kind of understandable business mistake, and they'll weigh that conduct factor, and they'll try to figure out the knowledge of your transaction. There's a difference between something your company is directly handling and something that you outsource, say, to a broker or intermediary or customer. Ultimately, the buck stops with you as the U.S. Principal party in interest, but your actual knowledge of the transaction in question will be a relevant factor when OFAC is looking at setting their penalty. They'll be looking at the harm to the sanctions program as well, and making sure they set the right kind of precedent, not too soft, not too hard, for deterring future action. So, for example, a simple paperwork violation that missed a reporting deadline or something like that may not necessarily undermine the entire sanctions program in a major way, but a transaction that allowed a warehouse in a focus area of potential military conflict area to restock its inventory and allow this conflict to keep going on and on is a pretty major vulnerability for a sanctions intent for OFAC. So those kind of actual results of the violation will be kept in mind. They will look at your compliance program if you have one. If you don't have one, they'll also keep that in mind. Or if you have one and you're not even paying attention to it, they'll keep that in mind too. They'll look at how you responded to the issue, and obviously your cooperation with OFAC will be a factor. If you're obscuring or non-responsive, that will probably not be good from a penalty number. But if you are, doors wide open, come take a look, that will help in that sense as well. And if you do find yourself in an enforcement case, it might just close internally, or you get some indication that there's no action there. If it's a little gray, they may issue you a cautionary letter to enhance your processes and keep getting better, keep investing in your resources for compliance. And they might issue a finding of a violation with no penalty. We see that pretty frequently on both the OFAC side and the export side, where they say, yes, we confirm this was a violation, but no penalty. That's a pretty common response or outcome for a voluntary disclosure that we won't necessarily get into today, but we have a kind of an enforcement specific session coming up in the 10-part series in a couple weeks. We'll get into that a little more. Or there could be a finding of a violation with an actual penalty attached. For some of the big cases, like the multi-million-dollar cases, usually there's some kind of settlement agreement, and oftentimes we will see what's called a deferred prosecution, where part of the penalty gets deferred for 1, 2, 3, 4 years, and would ultimately get waived if the company completes a checklist of things it has to do in the interim, such as revamp its compliance program, do different types of training, invest some number of dollars into the compliance team or whatever. And if they check all those boxes, part of that penalty disappears, and the prosecution disappears as well. But they have the cloud that it's still there if they don't go do their homework list, referred to as deferred prosecution. And then finishing up here, the facts may lead to a criminal referral. That would be bumped over to DOJ and potential other law enforcement agencies if the facts so warrant. Like I said, most simple business mistakes that end in a violation do not go to a criminal referral. This is for purposeful, willful types of violations. And then, as I mentioned before, another kind of potential outcome, like a collateral damage here, is that if you already have a license with OFAC, or you have an application that's getting reviewed, that may come into question if you are in the middle of an enforcement proceeding, and they may be unrelated businesses, unrelated customers, but you have a license to go to one customer, but you're really torquing off OFAC within enforcement in the other. They may be able to modify or suspend or altogether revoke that license you have, which would cause another business problem there. So the ripple effect of a OFAC violation can be pretty significant.
So, so we're heading into this next set of slides, aiming to make sure that you don't have to experience any of those, those heavy penalties that Alfredo was talking about in the previous slide. So OFAC strongly encourages organizations to develop a compliance program, and strongly develops is it's near mandatory in order to make sure that you avoid some of those harsher consequences that are the consequence of violations. Um, a They encourage that the policy should be implemented and updated consistently. In 2019, OFAC developed a document which provides organizations with a framework by which to develop their sanctions program. That document provides 5 pillars which OFAC believes should serve as the foundation for any sanctions compliance program. And the first of which is a commitment from upper management, which I think is seen by you all attending this presentation now. Prior to the establishment of any compliance program, management needs to be completely on board with the process. Adequate support in this regard ensures the program has sufficient resources at its disposal, and has legitimacy throughout the organization. It's OFAC's stated belief that a culture of compliance is necessary in order to ensure a program's safeguards are sufficient and properly followed, and that all will start from the top down. Such a commitment can be shown with management reviewing and approving a compliance program to start off, by maintaining direct and open lines of communication with those compliance officers who are in charge of maintaining the compliance program, and constantly being aware and recognizing the seriousness of compliance, and consistently aiming for complete compliance with your end result written program. I think you could move on to the next slide. So a quality risk assessment will serve as the basis for any quality sanctions program. The risk assessment itself identifies those areas of greatest risk for sanctions violations for a particular company. There is no one-size-fits-all risk assessment, and like the compliance program itself, once finalized, it should be tailored to the specific characteristics of your entity. Examples include the size and location. So a larger, more complex entity with lots of moving parts may need more numerous or extensive procedures and policies when engaging in certain transactions in order to best protect itself from potential irregular conduct when engaging in business dealings. We can look at certain customers. Some customers may be more savvy than others, or may have different thresholds of, let's say, well, let's say different thresholds. Alfredo, is there any, I guess, with customers?
Yeah, so
Yeah.
the customer profile is an important part of any company's risk assessment based on the nature of what they do, this their potential government connections or relationships, or just how risky of an industry in which they play.
So, and then looking at products, certain products, food, packaged food will be AAR 99. Those won't be a huge issue, but certain products, I'm not saying that you all are engaged in these, but nerve agents, those could be subject to strict ITAR regulations, and therefore might require much more sufficient or substantial policies in place in order to ensure that any transactions involving them are being properly conducted. And then we look at corporate transactions. So let's look at M&A. You want to make sure that take a look at the parties involved and their past dealings. You should be aware of successor liability when a purchasing entity buys an entity. They may be liable for the conduct of that previously owned of that purchased entity. So you really want to take a look at the past conduct of that entity and engage in extreme or sufficient due diligence when you're looking at such transactions in order to make sure that you are protected from liability even after the execution of the transaction. And then you want to take a look at your current due diligence practices. You really want to be honest here, because your due diligence is the level of due diligence that you have going on will really help shape the rest of the program. If you're not finding those weak points, if you're not finding those areas that may be taken advantage of, then a complete and full compliance program may not work to the best of its abilities. How frequent are you conducting your due diligence? How frequent are you conducting your due diligence? And making sure that it's adequate.
Yeah. So
Yeah.
before we move on here, the takeaway for me on the risk assessment part of the compliance program framework provided by OFAC is that this is what makes it customized to your business, right? There is no off-the-shelf compliance program. There might be a little boilerplate language you can use here and there strategically, but this risk assessment identifies your strengths, identifies your weaknesses, that's custom to you based on all of these bullets: where you play, what you sell, who you're working with, right? How you're set up from a corporate perspective. What are your processes actually doing in terms of potentially identifying risks on a day-to-day basis? How are you updating that on a recurring basis, given the dynamic changes of all these regulations? And with that, and oftentimes we do this as a third-party service, as counsel outside eyes for an organization to come in, ask a whole lot of questions about the business, kind of understand how they do what they do, and identify, based on these types of facts, where the risks are, and then design the rest of the compliance program based on this risk assessment as the core, set of data that you're trying to, fit around. So, go ahead, John.
So looking at internal controls, these will consist of the rules meant to identify, escalate, report, and maintain records relating to any potential prohibited activities. These internal controls will outline clear expectations, define procedures for compliance, and minimize any vulnerabilities that are uncovered during your risk assessments, as mentioned. So your policies and procedures are really going to set forth how an entity will conduct itself in particular situations. So, for example, when engaging in a contract with a new shipping partner, you may have a requirement that such contracts are reviewed and signed off on by your company's compliance officer. So some sort of procedure, step by step, in order to make sure that everything is verified and confirmed to conform with sanctions regulations. We want adequate screening and due diligence, which helps an entity recognize potential pitfalls in a transaction. Screening will take the form of both manual processes where, let's say, your compliance officer will research a transacting entity on the consolidated screening list to see if anything shows up, or it can be an automatic process where during preliminary negotiations or talks, the name of one of those parties can be dropped into your system's database and be automatically run for any potential negative points. This all is dependent on the actual characteristics of your entity at play. And then looking at record keeping, this helps provide an entity with a paper trail which demonstrates good conduct and a commitment to the safekeeping of critical information that may be obtained during a transaction. And the proper record keeping is useful in the case of any potential encounters or interaction with OFAC or any government actor, really, when you're engaging in your business in order to best protect yourself and ease any potential processes as you, I guess, interactions as you go with these government regulators.
Yep. And we're doing good on time, so let's pause here for a second because there's some good stuff here, but not a lot of words on the screen. So, depending on the size of your enterprise, if you're a small company, I won't be surprised if you don't have a sanctions policy in the mix for your company. But that's a pretty easy piece of paper to put together. The big challenge is making sure you have the internal resources and training to carry out that policy. And some of that is developing the procedures that make sense for your business. What types of transactions are you getting into? What are you selling and how are you selling it and how are you getting that into contracts and things like that. And as John mentioned, depending on the size and sophistication of your enterprise, some of the screening could be done on a manual search. Every time a name comes in, I go search it. I print out the results, even if the results are no results. That's a good thing to print out no results and keep it in your file. For larger companies that are dealing with thousands of international transactions any given day, there are paid third-party products out there that once it's always in your system. And as these lists get updated on a pretty frequent basis, it will automatically flag hits and things like that, hey, you have a contract open with XYZ Corp in Kazakhstan, and one of their executives just got added to some list because of something, some concern. So there's your flag. And then you got to deal with the immediate response of what do we need to do? Was our contract affected? Do we need to stop something? Do we need to go get a license or whatever? Again, probably not going to be a major issue for the small and medium companies at first, but as you grow, hopefully, the growth means more problems sometimes. And this is one of those where the expectation from a government agency as to how much due diligence updating you're doing scales up with the size of the company. So I'll keep it going from here. That fourth column in OFAC's guidelines are independent testing and auditing. And no matter how good your program looks on a screen or in paper, and no matter how good those policies are and your procedures nice and tight and your questionnaire has all it needs to do, if the people and the system isn't working as intended, that compliance program isn't all that useful for you. So one of the expectations of OFAC is that you're testing it one way or the other and auditing it. And those terms are related, but a little different. We'll kind of focus on the auditing for today. And scoping an audit is an important consideration because there is no right or wrong answer as to how to scope a sanctions compliance audit. If you have the resources internally to handle an internal audit, go for it. Probably cheaper that way. But if you just don't have the internal training you can bring in an external assessor who knows what to do, has a process, has done it a bunch of times, and knows the right questions to ask, and gives it truly independent type of opinion. You can't have necessarily your compliance officer do the audit on themselves because there is a little bit of a conflict of interest there. It's part of the considerations could be, would it be a planned audit or unplanned? And there's pros and cons to both of those as well. The planned piece allows people to collect all the information that may need, maybe relevant documents, and can be more efficient in terms of preparation type of priorities. Or the unplanned piece of it can sometimes be useful too, to kind of just catch people not expecting it, and really get an understanding of, do they know what to do, where this information is, how to go about it, show them what you would do in this kind of situation, and just kind of test them in a little more high stress type of situation, which can be insightful for some companies at varying stages of sophistication from a sanctions compliance perspective. Obviously, each company is going to differ a little bit on what they prefer there. And sometimes there may just be a specific element you want to look at. Maybe you just want to go back and rescan all the parties you're dealing with from a screening perspective, and kind of a look back on your screening. Did something get missed by way of screening? Has something changed by way of screening? And your audit is just focused on that piece of your compliance program versus looking at everything that goes into the compliance program. Again, depending on size and resources for the company, you could go either way or some combination. And again, depending if you're a multi-location business, maybe it makes sense to look at one location or one business division at a time, or look at something more enterprise-wide. No right answer for any of those things, and pros and cons in either case. A lot of times what the audits include is just a review of the relevant documents, questionnaires of your third-party partners, your customers, your distributors, et cetera, your screening results, your contracts, your financial payments, and things like that, without being necessarily like a full tax audit type of thing. And depending on what's found, maybe some on-site visits or some phone calls or virtual meetings with some of the knowledgeable people to dig more and answer any non-obvious questions from the paperwork. Really, at the end of the day, this audit is supposed to help your compliance program get better. If there are some vulnerabilities, then it was a successful audit in the sense that you can now go address those vulnerabilities so they become less problematic for you down the road. And OFAC likes to see too that if you've done this on your own accord for years, doesn't have to be every year, or the frequency can be calibrated to your company. But if they're seeing that you do conduct some independent testing and auditing on a somewhat regular basis, and then you take the findings and actually improve the system, those buy some really good brownie points from an enforcement perspective. And obviously, the person conducting the audit, arranging it, has to have enough authority to take action after the audit, and really during the audit and after the audit. So that requires, back to John's first point, management commitment and the culture of compliance, and the fact that this is a serious undertaking. And then that last column of the compliance program expectation is that training will be an integrated, essential part of any compliance program, right? Similar to how I said, having the perfect documents is a good thing, but without the right staff training, it's not that useful. In terms of frequency, OFAC in their document references an annual frequency as being pretty standard. That's what we see a lot of the times with small and large companies. Or if an audit identifies a major issue, like it can't wait 8 more months until your annual audit or your annual training comes up, an ad hoc, unscheduled training needs to be arranged, because if it's presenting a chance of ongoing vulnerabilities and violations, it needs to be addressed sooner than later. In terms of who's getting trained, we do recommend everybody in the organization get at least an awareness training. Doesn't have to be long. I've recorded one for a client that was 22 minutes. It is just like a heads up that this exists. Sanctions exist. This might affect your job directly. It might not, but we want to be able to say that at least all of our people have done this, and they do that annually as just a bit of a refresher. Keep it, bring it back to top of mind because it can affect different business processes as well. And then certain roles, of course, will require a more detailed training. If their day-to-day job involves more international trade, contracts, purchase orders, shipping, etc., they may need some more detailed training. So that would be a subset of a total workforce. And we, of course, recommend attendance logs. For your own internal tracking and making sure nobody slips through the cracks if they were sick for the day training was offered or whatever. And then perhaps more importantly too, you'll be able to show that to an OFAC enforcement agent if something like that should ever happen with an on-site visit or a request for information. You have the documentation that you have been training your people, and that goes a long way. Now we're still doing good on time. I'm glad that's not always the case for me, but our last substantive slide here is a sanctions resource page. There's a lot out there. We've thrown a lot out there, even at this introductory level today. We do recommend, if this is part of your regular job, role, to get on the OFAC email list. It's not overwhelming, maybe a couple emails per week, but they send things like updates to the SDN list and other lists as relevant. If there is a big enforcement or settlement case, they'll send some news out on that or press releases about it. That's how I caught that big North Korea one that involved cigarettes, of all things. The emails also bring out guidance if it's released, and an OFAC has a very extensive FAQ section for all their sanctions programs. When new FAQ questions are loaded or revised, we get an alert there, or if new general licenses get put out or revised, that gets blasted out to the email list. So it is just something that you can scan it usually in 2 or 3 seconds, figure out if it's relevant to you, and move on or click into the link if it's important. I also had a question in the chat about where that framework for OFAC compliance commitments could be found. The link is here on slide 23. I don't think you can click it, but you can jot it down. I also have it in the chat in direct response to one of the questions. Actually, maybe our audience members can't see the Q&A section, so they may not see that. But anyway, here is the link, or if you Google the name of that document, Framework for OFAC Compliance Commitments, it'll be one of the first links that come up in the search. And then just a quick note, if you had looked at the OFAC website a year or more ago, if you go back today and you haven't looked at it since, it'll have a new look and feel. They just rolled out a new optical look. They rearranged some things, added some new resources. So it's worth a click through the new website if you haven't been there in a while, but just wanted to note that they refreshed that very recently, I think in March or April of this year. All right, and I think that's it for us for the actual presentation, Tony and Brian.
Yeah, fantastic. Thanks again, fellas, for coming on and being our subject matter experts for this very serious topic. We do have some minutes left, but we also have about 6 or 7 questions that have been written in as well that I received via email. Okay to go over them with you?
Yeah, please. Yeah, happy to use the balance of our time.
Let's see if we can fire this along. Can you please explain OFAC's 50% rule?
Sure. The rule states that any entity owned by an SDN at a percentage of 50% or more will be considered an SDN itself. That entity may not show up on the SDN list, but it is nevertheless considered an SDN. And it doesn't necessarily have to be one SDN that owns it. That 50% number would be relevant for the aggregate ownership of potential SDNs. So let's say, for example, there are 3 SDNs and one owns 20% and one owns 20% and another one owns 20%. No one SDN owns 50%, but in aggregate, they own 60% of that entity, and that entity doesn't show up on the SDN list when you search it. Doesn't
Okay.
really matter. OFAC considers that owned entity an SDN.
Very good. Thank you so much. Is OFAC accessible for questions regarding licensing applications?
You would have to ask them that.
All right.
There are some there's an email address, I believe, out there where I've had mixed results with getting the answer I'm looking for on behalf of a client. But they generally are available. They hold themselves out as a customer service agency, and for the most part, our dealings with them have been professional and respectful and sometimes helpful.
Great. Yeah, I think we understand. How long does it take generally or general case for OFAC to process a license application? And are there fees?
Good question. I have not had to do one in years, just because our clients have either figured out they're completely not going to get the license, so why bother putting one in, just because if it's squarely within a sanctions goal, for example, Russia being one of those recent ones,
Sure.
or they're very clearly in smack in the intended scope of a general license. So in terms of recent turnaround time, I'd honestly have some trouble guessing. But if I'm using other government agencies with more recent work, I'd say 6 weeks is a good
Benchmark?
point of departure for an estimate.
All right. Moving on to, does the consolidated screening list identify OFAC sanctioned entities, etc.?
Yes. The consolidated screening list is a combination of various U.S. government lists. It doesn't have non-U.S. government lists. But if it's on an SDN list, the SDN list, it will show up in the consolidated screening list. It has the SDN list and then some.
Okay. Here's another one. Are there such things as a voluntarily self-disclosures engaging with OFAC? I guess there.
Absolutely.
Okay, go ahead.
Absolutely. And we'll get into that a little bit on the enforcement session of this series. But absolutely, if you discover an OFAC violation on your own accord, a voluntary disclosure is sometimes a very good idea to just get it in front of OFAC, full disclosure. And in our experience, they look at that very favorably and if it's not a major issue in terms of what the violation caused, they are, without guarantees, likely to say, we agree that was a violation, thank you, but no penalty, and keep improving your compliance program. Have a nice day.
Great. How do deemed exports relate to OFAC sanctions?
We're going to need another hour.
All
But
right.
the deemed export piece is a little more geared towards the export regulations, and this is related, but it's a good question. Like, for example, sharing a piece of ITAR controlled technology with an Iranian citizen who's in the United States may be a deemed export to Iran, and likely a violation if not licensed.
Sure.
It may not necessarily be an OFAC violation. So there, on the Venn diagram of things, there's some intersectionality and others where they're kind of unrelated topics. But if there are some specific questions, feel free to reach out to John and me via email listed here on the slide, and we can talk that through.
All right, 2 questions left. Can you appeal an OFAC license decision? You might have touched on this, but
I don't see why you couldn't, but it would likely be, providing more information if the concern was they didn't understand the anticipated transaction well enough. I've never been in a situation where
sure.
we've had to look into that. But I think it would just kind of be a new application referencing the rejected one with more information and maybe adding clarity, and you'd have to essentially start over the application process and timeline.
All right, understood. One last one. If we are checking the CSL list consolidated screening list for each export, do we need to check OFAC's list as well?
Well, the CSL should be would be also scanning OFAC SDNs and non-SDNs on their lists as well. What would not, so from an individuals and corporate entity perspective, the CSL screen is usually sufficient for most companies most of the time. What it wouldn't catch is if you're sending it to a generic person in one of those embargoed areas. Just like not every citizen of Iran is going to be on that list, right?
Sure.
But just because they're not on that list doesn't mean you could send your export to Iran because it didn't have any hits on the SDN list.
Sure.
Obviously, the geographic destination is an important part of the overall transaction diligence.
Fantastic. Well, gentlemen, I'd like to thank today's subject matter experts, Alfredo, Fernandez, partner with Shipman and Goodwin, and also John